ask this question bearing in mind the Constitutional Review Commission's recommendations in its white paper that the justice should be capped to 15. Right? What's your view on that?
If it were possible to cap it by legislation, so that it will be purely a responsive capping. As strictly speaking, the US 9 is. It is by legislation. In Canada, it's by legislation. In India, it's by legislation. Same in the Republic of, the Republic of Ireland. Yeah, that will not be too bad. But to the extent that, and then maybe it's debatable, maybe it's something that can be attempted and then somebody can challenge it and then a decision can be made on it. But I'm of the view that, and these days my views don't matter because they're not any, unless the matter is sub judice. Okay. And my view is that the Constitution chose to set a minimum. It did not set a maximum. Therefore, the Constitution chose to set upward numbers at large. Yes. So if you want to now cap it, then you have to cap it at least by a constitutional amendment, which would say that, which will empower Parliament from time to time as the demands as public demand or the demands of the court services dictate, to set a maximum. But until that will have to be a constitutional permit before, in my view, Parliament can decide that we have set this maximum 15 for the Supreme Court. Even if it says it can be revised from time to time, that leverage to swing this way and that way is not available at the moment. That's why I think it has not been done. It should have been done long time ago. Yes.
If the argument you're making is anything to go by, it's something that may be worth considering if it's going to, for instance, enable the creation of special chambers and so on and so forth. But should it be by a constitutional amendment or by legislation? Quick one.
Which one? The creation of the capping? Yes. Oh, I'm saying that it cannot be.
Conventional practice is enough.
I think that in the best of all possible worlds, the conventional practice is enough. Of course, people are always afraid that there could be some really, evil-minded executive that would decide that I'm going to do my own thing and I'm going to I'm going to appoint 30 Supreme Court judges. I think that would be very difficult. You see, because the process, imperfect though it is, the president just doesn't get up and say, I've nominated 20 people. No. The nominations to the Supreme Court originate from where? From the Judicial Council, which is also a different body chaired by the Chief Justice. So such a president will need the buy-in of the Chief Justice who is chairing and the Judicial Council, which is made up of, yes, in my view, there are too many people on the Judicial Council who can who are nominated by the president. I've always felt that's an overkill. But on the whole, most of the membership is ex officio. The Judge Advocate General, the head of legal police, the president, the national president of the bar, and then representatives from the regional bars, the dean of the University of Ghana School of Law, and then so that is how, and then judges from, there will be a Supreme Court judge, there will be a High Court judge, a Court of Appeals judge, and so on and so forth. So all these people, they're not just going to sit there and a whole bunch of yahoos appointed as justices of the Supreme Court. Not even judges or magistrates, let alone justices of the Supreme Court.
You agree that
so conventional.
But the conventional practice has its own imperfection.
Yes, but other than if we're prepared to go through a constitutional amendment, that provision will have to be by referendum, because it will be tinkering with entrenched provisions.